We're going to go ahead and open up our next informational hearing. This is on the presentation on invasion of privacy. We have 3 individuals that have been invited to testify. Crystal, why don't you go ahead and come on up? And I think what we're going to do for Tom and Laura, thank you very much for being here. Crystal is a mother of a juvenile who was in a situation in Springfield. I think what I'd like to do is let her go ahead and give her testimony now, and then we'll follow up with yours, and then we'll take questions. Crystal, thank you for coming up.
Thank you. Good afternoon, Chair Przansky and Chair Barker, wherever you are.
Right here.
And members of the committee. For the record, my name is Crystal Stutzman. I am speaking here today not only on behalf of my 10-year-old daughter, but for all future victims of voyeurism in the state of Oregon. Our world has been turned upside down after our neighbor was arrested for allegedly setting up hidden cameras on our daughter in her room for possibly up to a year. Disturbing letters were found demonstrating this person's sexual interest in our daughter, and even details his stalking of her and even a possible attempt to have picked her up from school. As upsetting as all of these facts are, it was even more upsetting to learn that if found guilty, this man only faces being charged with a misdemeanor, and that the sentence for the crime of invasion of privacy is currently set at only a year. The privacy laws here in Oregon make no distinction that this crime is any more serious when committed against a minor, so another adult taking a secret video or picture of another adult faces the same charges and punishment as a 63-year-old man who films a 10-year-old girl. Nearly half the states in the country have already replaced their privacy laws to catch up with the technologies available today, and most have heavier penalties in place for these types of offenses when committed against both adults and minor victims. Modern technology is giving a perverse and deviant population a whole new advantage to victimize not only adults, but our most vulnerable citizens, our children. It is not required anymore for a peeping Tom to sneak up and peer into a window. These individuals can now purchase very easily hidden equipment or a simple cell phone to store and share what they are attempting to see without our consent. The United States FBI asserts that individuals who engage in offenses such as voyeurism may also have a propensity for violence based on the behaviors of serious sexual offenders. And Stephen Thompson, a sexual assault coordinator at Central Michigan University with 27 years experience in studying sexual aggression, states, "It's not to say that a voyeur is a rapist, but rapists frequently start out with voyeurism." These crimes can touch any of us, and it is my hope that Oregon will give judges the ability to sentence a perpetrator based on the severity of these crimes, and will recognize that these individuals need to be appropriately punished before they rape, kidnap, or murder someone. I hope to show my daughter that her government cares about her privacy, safety, and security, and that this traumatic experience has not entirely been in vain.
Crystal, thank you. Let me just see if there's any questions for her. Crystal, you're more than willing to stay there at the dais if you'd like. We're going to have the 2 professors give us their perspective, and then we'll open up for discussion then. So, Laura, Tom, whoever would like to start off.
Thank you, Chair Przansky, Chair Barker, and members of the committee. My name is Tom Leininger. I'm a professor of law at the University of Oregon School of Law, a former prosecutor for nearly a decade, used to be the chair of the Oregon Criminal Justice Commission. My most important credential is that I'm Representative Hicks Evidence Professor. And I do recall telling the graduating class, was it 2008? Yes. That one among them was bound for stardom in politics. And I said it was Wally Hicks. At the time, didn't have a political office, but that's one of the few graduation day predictions I ever got right. Today, I'd like to share with you some thoughts I have about privacy laws in Oregon. In particular, I received a phone call 1 week ago from Bill Taylor asking if there might be any way Oregon should consider strengthening privacy laws, and 3 avenues occurred to me. One was the stalking law. One was the invasion of privacy statute, which, as you mentioned now, prescribes a misdemeanor as the sentence. And one was a tort action for invasion of privacy. Among those 3, the best vehicle for reform seemed to me to be the second one, the invasion of privacy statute that you mentioned. I would leave to the committee's judgment, of course, what the appropriate punishment might be, but it occurred to me that this statute is presently under-inclusive, that unlike most other states, Oregon only has criminalized a fairly narrow range of invasion of privacy. So I wanted to share with you today, just for the purpose of discussion, a proposal that would capture some conduct that is criminal in other states but is not yet criminal in Oregon. In particular, I wanted to point out that the present version of Oregon's statute, ORS 163.700, creates a crime to do one of two things: either to basically film or photograph someone who's nude or partially nude in a place where that person has a reasonable expectation of privacy, or separately, to view someone from a vantage point that is not a public place, as defined in another statute, where the person viewed is in a state of undress. And I'd like to suggest there are three ways we can improve that statute. As some background, in Eugene, Oregon, we've had some trouble with peeping Toms. Many of them sneak onto the grass and other common areas in apartment buildings to peer through windows. I know there's a similar problem in Corvallis, and of course, you hear stories from time to time about drone, planes that someone might attach a camera to. And I was hoping to broaden the scope of coverage without making this statute any greater than the bounds of other states' statutes. So three proposals I had in mind. First of all, would be not to restrict the theory of liability to a situation in which the person viewed is nude. And let me suggest why I think the present restriction is under-inclusive. That statute arises from some 1997 case in which a proprietor of a tanning salon had installed cameras to view women while they were dressing and undressing for the tanning salon. Because the statute was focusing on the issue of nudity, it wasn't intended to be a comprehensive regulatory scheme for all invasion of privacy, and it's pretty dated, 1997. I think what other states have done instead is to find that where the predicate of an intent to arouse or gratify sexual desire exists, it's not necessary that the person viewed also be nude. I think that approach is preferable. That approach captures conduct where, through serendipity, the viewer just happens to look in a window where the occupant is not presently naked. I can't imagine a good reason to exempt such a person from prosecution. Also, such a person might be gleaning information to facilitate a later break-in, or at least seeing such a person in your window is psychologically harmful. So I believe Oregon might want to expand the scope of liability to basically import some language Washington has, and I'd suggest respectfully you might consider including it. If you look at the bottom of the bill I've distributed for discussion purposes, subpoint C is new, and that's a statute Washington's had for, I believe, about a decade. It's withstood all sorts of challenges. And it would supplement the foregoing provisions and then say, for the purposes of arousing, this is another person who commits a misdemeanor, one who, for the purpose of arousing or gratifying the sexual desire of any person, one who knowingly views, photographs, or films another person without that person's knowledge and consent, while the person being viewed, photographed, or filmed is in a place where he or she would have a reasonable expectation of privacy. To me, it seems redundant to require both the predicate of intent for sexual gratification and then also the good luck to have found someone nude. It seems like the predicate plus the invasion of privacy is the majority approach. Also, I suggested that Oregon consider importing Washington's definitions of photographs or films and views. There are two other changes, this will just take a second, that occurred to me that I think would be a valuable reform of the present ORS 163.700. The definition of reasonable expectation of privacy is narrower in Oregon than it is in other states. I think that's inconsistent with our state's tradition of protecting privacy at least as carefully as other states do. But what I think for the sake of notice, the statute sought to indicate non-exhaustively a list of settings where one had a reasonable expectation of privacy. And if you see on about halfway down the back page of this proposed bill, it indicates places and circumstances where a person has a reasonable expectation of privacy. Now, I believe due to the unique facts of the case to which legislators were responding in 1997, that is, photographing customers in a commercial setting, a tanning salon, the list of places didn't really list residential settings. It focused more on any bathroom, dressing room, locker room that includes an enclosed area, tanning booth. It's very customized to that particular case. The Supreme Court over the last decade has indicated emphatically the importance of protecting all rooms in a residence. Another case this spring just drove home that theme. So I would respectfully suggest we include in the list of illustrations of protected spaces all residential rooms to eliminate any ambiguity, to assist in clear jury instructions. The final proposal I'd suggest would change what is now presently an exception to the reasonable expectation of privacy. This exception says if the viewer is in a public place as defined in another provision that is not, solely intended to apply to invasion of privacy. If the viewer is in a public place, there is no expectation of privacy. And I think maybe I've exaggerated the importance of that provision because it modifies not only the last antecedent but probably some other language too. Assuming that it's an important provision and that it modifies and creates an exception to the reasonable expectation of privacy, it seems overbroad. It seems that, I'll list the particular language that concerns me. There's language in the definition that says a public place includes a common area, it includes a hallway, it includes a yard of a property that has an apartment building, of a property that has a hotel. And I suggest respectfully, you might want to deny a trespasser the right to invoke that defense. If somebody and I'll give you an example in Eugene. We have, in Senator Przonski's district, we have a lot of apartment buildings surrounded by grass and yards. And if the present definition of public place includes every part of that property that is not an apartment, then it's hard to prosecute someone who walks up on the grass to peer through the window. Hard to prosecute someone who's a trespasser who comes into a hallway and looks through the window, because I believe the present definition sort of categorically treats all such common areas as vantage points where the viewer defeats a reasonable expectation of privacy. I'd like to exempt trespassers, people who shouldn't be on that property. Now, I realize that the reforms I had in mind don't address your concern about the need for stricter sentences. I think the committee's in a unique position to know, what the best sentence would be, and I don't offer any guidance there. I also recognize that my friend, Professor Appleman, with a background in criminal defense, may have some concerns about the breadth of what I've proposed. But I'd be happy to answer any questions at whatever point you might have them.
Yeah, why don't we go ahead and take Professor Appleman's testimony. I was surprised, Tom, that you went first as a prosecutor. I thought you'd want closing, but here it comes. Professor?
Good afternoon. I'm Laura Appleman. I'm Associate Professor of Law at Willamette University. As Professor Leininger has alluded to, I was a former appellate defense counsel for the poor in Manhattan for 6 years. And just point out that my opinions represent only myself, not Willamette University's or anyone at the Willamette University College of Law. That said, so I actually don't have too many concerns with these possible changes to our invasion of privacy bill, except for maybe, and not to go on too much about this, this last part of public view, because I do have concerns that if we, going back to the example of, say, places that are supposed to be public places, say the grass around an apartment building, I'm concerned that this might start, if we restrict that too much, then we're going to start touching on people's freedom of association. And so I think, not that this last part is wrong, but just perhaps needs to be, I think, carefully looked at. But I do want to sound a note of caution on all of this. I think there's been a lot of anxiety, even hysteria, especially about drones lately. Primarily about the government spying on us, right? But also the fears of the use of technology. And as a mother of a small child, I can appreciate this. That said, I would urge caution on promulgating a whole bunch of new laws. I don't see Oregon as a place that is particularly lacking in criminal laws. What I like about Professor Leininger's proposal is that it takes an existing law and tweaks it a little bit. I mean, as a former defense attorney, I will, of course, also give a plea to the committee that if you are going to change sentences, you do so with an eye towards our burgeoning prison population and our current difficulties paying for that. But I think more broadly, it's important to distinguish our standard understanding of a reasonable expectation of privacy. Remember, that is from the government, right? So what Professor Leininger was talking about with all these new cases coming down to the Supreme Court about privacy in our houses, that's from the government. And so, everything we're talking about, these criminal statutes are dealing with one citizen, potentially invading the privacy of another. So I'm not entirely sure that the protections that we, provide against the government should necessarily be quite as broad for the individual sphere. I think as for technology, yes, I think everyone has concerns about how it can be used. I live in Portland, so there's been less of a peeping Tom. Quite honestly, I worry more about Google Earth, right? So Google Earth, which is something that none of us can do anything about, is taking pictures of everyone and all of us and in any parts of our houses. And so, can we stem the flow of technology? No. I do think we can beef up a little bit our invasion of privacy. More than that, I would urge the committee to be cautious in adding a whole new raft of laws. And then I'll just hook myself up to questions. Thank you.
All right, thank you. Questions to start, Representative Hicks.
We should add them to our drone task force, I think.
Yes. Representative Hicks.
Thank you, Mr. Chair. So, in law school, it's the professors who get to ask the questions, so now the tables have turned. But I won't belabor. I do have a couple points about the proposed language. So first, we've been pondering some, the sexting phenomenon. And so we've been pondering some variations on how to address that. It's currently considered a pretty serious, or could be considered a pretty serious offense. And so reviewing the language that you proposed here, particularly paragraph on the second page, 2A, you've got included in making or recording a photograph, inducing another person to make or record, and then you've got reference in viewing as being with an unaided eye, but I wonder if you could address whether through some formula this would address the sexting situation of one teenager, for example, perhaps induces another teenager to take a photograph of a person, and so is that comprehended by this statute?
Excellent question, Representative Hicks. And I think the quote from the cartoon was, "Ain't so funny when the rabbit's got the gun." I do believe sexting is an important concern. I have a teenage son myself and worry about that a lot. This statute already will address, before the revisions, will address some aspect of sexting. That is, taking a picture of someone who is reluctant at the time of the photograph. As presently written, I don't think the statute or the revisions I've come up with address well the question of a consensual photograph that is later transmitted without consent.
Okay.
So if the intent were to capture that, I think you would need to add some language, and it's a concern that makes sense to me. I did want to point out there are two contrasting approaches to the photographing of people who are nude. Oregon has criminalized merely photographing a nude person without his or her consent. That's a misdemeanor. Washington has created, I think, a felony for with intent to gratify the photographer's interest or some other person's interest, photographing someone who's nude without his or her consent. So Oregon actually is more restrictive in that one narrow respect. But I think what the sexting concern you raise addresses is the need perhaps to capture that conduct after the consensual photograph, that is the distribution of the photograph. And I don't know if tort law is the right place to get that. I don't know if criminal law is the right place to get that. But it's not in either the bill or the law as it now stands. It's so long as the initial photographs consensual.
Okay, one more?
Yes.
Okay, and thank you. So just one more question in regards to 1C, which is the last few lines of the first page, and a couple other points you've got for the purpose of arousing or gratifying the sexual desire of a person. And so that does go toward sort of motive? In a
I
way?
didn't hear.
Does that go toward motive? It sort of suggests that motive is going to be an element
right,
of the crime.
motive.
And could you expound on whether that's how common is that to have crimes that are inclusive of motive as an element?
So we just had this conversation. It's a very reasonable question. I was surprised when we did the 50-state survey to find out how other states were approaching this. What I believe to be the most common approach is for a state to criminalize photographing someone in a private setting, a setting where there's a reasonable expectation of privacy, where the purpose of the photographer is sexual gratification. I just wondered how you prove that. Now, email, the history of interaction between the photographer and the subject, maybe a spurned suitor, maybe the conduct of the person. In some really creepy cases, the contemporaneous conduct of the person indicates an intent for sexual gratification. But that is the most common approach in the other states. And so what they do is they don't restrict it by looking at, I suppose, Representative Olson would have a lot of expertise as a former police officer, but it seems hard to reward the good luck of a defendant who happens to set up and photograph a room where the person's not nude today. It seems like the better approach would criminalize intent, even though it's hard to find, so long as he appears in a private space. And other states have made that work for decades, so I assume we could make it work too.
Can I just follow up on that? I mean, essentially, Representative Hicks, you're pondering whether to make this an intent crime or strict liability. And of course, actually, my response to you, I do have some concerns about that, is, if you're videotaping, then I think you might, you could make this obvious that if you could have something in the bill that says if you are videotaping someone's bedroom window, maybe you can assume there is intent. I think there's one way to get around it, because there aren't a whole lot of good reasons why you're, videotaping someone's window.
That does make me think of one contrast I'd like to draw. Oregon's existing law doesn't require intent for sexual gratification when you film a nude person without that person's consent in a private space. So we already capture that pretty well. What Washington's version does is add the intent predicate and broaden the list of things that, if photographed, would trigger criminal liability.
Right. Senator Roebelin.
Yeah, I just want to follow up on that, because that was almost word for word in our sexual abuse statutes with respect to intent of touching or whatever person. And so is that where that partially came from? Because having been a high school principal, that's something we care about a lot in trying to deal with things. And so when I was listening to your testimony, I was saying, wow, they pulled that right out of the statutes that exist.
I don't know what the original source was. Where I copied it was from Washington's version of the voyeurism statute, but it may very well be common in many contexts, and I think that makes it more manageable if, as you point out, that language appears in other contexts. Then I suppose officers and courts are more familiar with what it takes to prove it.
Representative Olson.
Thank you, Mr. Chair. So, Tom, when you were doing a review of what some of the other states were doing, any states have kind of a stair-step approach, like a second conviction within a 10-year period of time, elevating what the sentence structure would be?
They do, and I apologize that I don't have that information in front of me. The easy way to find that information is to run a search for National Association of District Attorneys and voyeurism statutes. There's a 150-page memo that has all of the statutes side by side from within a few years.
The easiest way is to turn to our counsel,
Get it for us.
and Bill Taylor, and say, Bill,
And I'd be happy to follow up with Mr. Taylor, but I was paying less attention to the sentencing provisions, but I do recall that some did have that stair-step increase. I think that's a sensible approach.
We like that, too.
Representative Barker.
Thank you. And I read some of the case facts in your case, and I'm appalled, and somebody would be filming a little girl from a neighbor. I mean, it's just like, we've got to do something about that. I knew an adult who had somebody who had an interest in him, a neighbor, who had a camera set where he could watch him. So his first reaction, he was going to shoot the camera off the guy's house, and then his dad said, don't do that, it might upset more than just the neighbor. And so he went and told the neighbor, don't point that camera where I, to watch it. So I have it for my dogs. I'm watching my dogs was his excuse. But he said, well, if you don't take it and turn it, I will shoot it off. So the guy moved his camera. And about Google Earth, it isn't. Nobody can do anything about it. Dick Cheney made them disguise his house, so, on Google Earth. So for some good reason, I think he had to do that, But anyway. But these are really concerning things. Like you say, the filming. I remember the case up in Portland there of the tanning salon over on, it was off of Foster there. But I had raised 2 daughters, and I can't imagine what my reaction would have been in that case. It would not have been as good as yours, I'm pretty sure.
Well, and if I could note something else too, since they're talking about the details of the law, there's a lot mentioned about an expectation of privacy, and a lot of the cases that I found on voyeurism are cases where someone is filming someone up their skirt as they're walking around, or a child in a Target in, dress. So I think sometimes the wording that there should be an expectation of privacy, well, I'm sure she assumes that there's privacy up her skirt right now. Yeah. So, I think that is something that I had mentioned too, that the expectation of privacy, we should be able to have a level of privacy from sexual intent when you're out in public. And I think that's where kind of the intent falls into, is obviously you have a sexual intent if you're trying to film up somebody's dress in public. So,
in a few years back, we had a case where there was a guy who had a camera in bathrooms and was filming young girls in I don't remember if it was in public, I think it was in an office bathroom, and we found there was no prohibition because of the way the law was written, so we did correct that one.
Any other questions? Any other comment?
That comment, that took expectation to a whole different realm than I had ever thought of. That I like.
What makes sense?
Yeah, oh, it absolutely makes sense. But that's.
Well, yeah.
Professor?
Although, just to restate the law, of course you have a bodily privacy among you, but if you are in a public place, your reasonable expectation of privacy is much, much lower. I mean, when we're talking about, in this bill and all these bills need to focus on the home. That's critical. Once you get to your person, that's not really reasonable expectation of privacy as we understand the law to be. And I think the part of the problem is that there's a public understanding of reasonable expectation of privacy and invasion of privacy, and then the legal understanding. And so, Professor Leininger's bill, I think, nicely really focuses on the home, which I think is, if the committee is going to act, is probably the most important place to start.
All right, thank you. Representative Hicks, did you have?
I would say perhaps a way of getting at that, just a whiteboard idea, is you've got in 2C, you've got places and circumstances where a person has reasonable expectation of privacy.
Yeah.
And the proposal actually has the word places removed and replaced with a place and circumstances, which would add another. So perhaps not making that change and simply saying places and circumstances would cover the public place, but reasonable expectation of privacy because of the circumstances. So I would propose perhaps reviewing that.
I think that's an excellent point. The reason, if I wasn't a tough professor, boy, I'm taking a grilling today.
Reading.
The reason why I suggested switching from places to a place is that the uses of those terms in the prior language is all in the singular. So it defines places, but the term appears previously as a place. So if we were trying to make it more exhaustive, you might just replace it in all places as places. So I think that makes a lot of sense. I just wanted to make it uniform.
All right, so
Just one more comment, Professor. I want to point out, I won't call him a star yet, but we have hopes.
all right, so I appreciate everyone being here again. This is one of those informational tee-ups to give us an opportunity to kind of see what we may be working with during the interim. Crystal and I had an opportunity to have a detailed conversation a while back talking about how our process will go, and so I expect that the 2 chairs are going to be working to try to strive to do something hopefully for February if we can get everything together. But as everyone can see, it's very complex. It's not just as simple as making one change, because you have to see, is it really going to be inclusive? We do understand that our statutes do need to be updated to be more in line with what technology provides today, and at the same time ensuring the privacy that I think all of us expect and would like to have for ourselves and for our families. Any other comments? Thank you very much.
May I indicate, Chair Przanski, if I could be of any further help doing research, I have some time this summer.
Don't worry, we got you on the books.
You're on the speed dial. You're